and 32, CD not received.
Lordship, in the item number 27, interim order to be continued.
CD not received. In 27. 32 no interim.
And my lord, item number 32 kindly pass over the matter for the day, as my senior Mr. A.A.R. Karim is out of station.
List again. No.
Obliged, my lord.
For 38.
Hmm?
38.
38.
Lordship, in the service report, they waited. After 2.
The prayer of learned petition list the matter of 2 weeks.
Orders. In orders.
Interim order passed earlier to continue.
Obliged.
Table session. I have to mention item number 54 of pass over for the health service. After tomorrow,
Number
54 of supplementary.
right 54. Prayer of learned list.
After tomorrow.
Wednesday.
Yes. Obliged.
Yes.
Yes, Your Lordship. I beg to mention for the list of I, we have already have filed it. Kindly list them. Yet,
To senior bench.
Lordship, just for the correction of the order.
Correction.
And Your Lordship, I beg to mention item number 50 of supplementary list. Lordship, conducting counsel, Mr. Alajuddin is not able to appear to the duty. Kindly may fix the matter after the week.
All right. After a week.
I have to mention item 33.
34.
33. Daily 33.
43 CD received.
The leading house out of
All right. Day after tomorrow. When? Huh? Next week.
uncle expiry.
All next Monday.
Pleasure.
Huh? Yes.
There is an interim order.
Interim order first. Continue.
Yes, Your Lordship. I want to mention regarding listing of I, Lordship, for correction of order, Lordship. An order has been passed by this honorable. Ashok.
Consent from the other side. I beg to manage. Item number 13.
1-3. Yes. When do you want?
I'm for the respondent.
Prayer of learned counsel for the respondent with the consent of the other. Is the matter again not? Even
Lordship, interim is
interim order first. Till the next list.
So for the time being.
Chanmari ke. But last content bill on Thursday, mal. he might be here, can he also was on, it was granted on 13/11/2020 in their number.
Day
362.
after tomorrow, I don't think it will be possible. Is it?
Yeah.
Anne-Marie,
Friday.
Friday. We can have it on any day,
Thursday, madam.
Thursday.
Thursday. Okay, is the obligation.
The petitioner is behind bar for 32 days, but the petitioner is not a FIR named accused, my lord. Out of the FIR named accused, my lord, two FIR named accused file anticipatory bill, they are granted bail in motion itself. FIR is at page number 11. All the FIR named accused have already been granted bail, my lord, and two are granted anticipatory bail in motion. I have annexed this offer, my lord. Petitioner is not the FIR named accused. And four are the bail order. Page number 20, my lord. And exactly is the accused number 2, my lord. Granted anticipatory bail in instance by this honorable court. Sultan Ahmed. Page number 20. And the order reflected that, my lord, the kidnapped already been recovered long back. Other and
You are Kamrul Haq.
yes, ma'am. That forwarding is that page number 20. The 5, ma'am. The forwarding. The anticipatory bail which granted, ma'am, they are accused number 2 and 3, ma'am. Ahmadu. Anna.
But in your forwarding report, it is said that
They
you were
kidnapped,
directly involved.
yes, they kidnapped, thereafter demanded ransom, and my lord, from the clutches of these victimized persons, were recovered, my lord. And thereafter, there are separate forwarding report itself reflects, my lord, specifically that
Now, CD.
Added.
We did.
on my lord, 4th of December.
Yes, my lord, are for us.
Hmm? Speak on the microphone.
But in this case, the petitioner is, my lord, behind the bar for 3 days, my lord. Page 12 is the FIR. It's under section 10, 31 of is the driver.
All right, CD.
On 2nd of December. Right.
Read. 482 application lordship offense under section 108. Abatement of suicide. Kindly see the FIR first, lordship page 9. Present petitioner's name have not been mentioned in the FIR. They are brother-in-law of the deceased lordship. What happened, lordship? The daughter of the informant committed suicide, lordship, by consuming poison. And the incident took place in a brick factory. And petitioner was present at his own house, lordship, far away from the house of the place of offense.
How are you related to accused?
I am the
Bel-
younger brother of the family member.
Accused number one.
Yes, lordship. Our name has not been mentioned in the FIR. Being a family member's lordship, police investigated us, lordship. So, lordship, till the lordship, you may be protected, lordship. And occurrence took place, lordship, far away from our house, lordship. And they are living separately also.
Our learned counsel for the petitioner and learned edition 50. This is an application for pre-arrest. The allegation as reflected in the FIR is that the daughter of the informant committed suicide, the result of being subjected to mental and physical torture by her husband and in-laws. Call for the CD. It appears that the present petitioner is, who is the brother of the accused number one, is not named in the FIR. And it is submitted that he is separately from the house of the accused number one, having regard to the above provided petitioner the event of his arrest connect be released on interim pre-arrest bail is 2001. That is
Deeply obliged.
further provided that the petition appear before the IO within a period of 7 days.
Deeply.
FIR is placed 10 million after 14 years of marriage million. The instant FIR was less than kind. One. A laptop. Marriage was took place in 2012.
There is attempt of murder also involved.
For that,
Part of this.
Interim bail application lordship, FIR is at page 10 lordship. Type copy of the FIR. There is not a FIR name accused. There was a regular accident between the informant side and the friends of the petition. FIR reflects lordship sequence of the accident lordship. First, front of a restaurant lordship, and second, front of a hospital gate lordship. The first instance, I was not there, lordship. My vehicle was found on the spot. Being informed, lordship, I was there in the second hospital, and I was also assaulted by the government side, lordship. I abandoned my car on the spot, lordship. I fled away, saving my life. I have annexed the RC, that white, lordship. They mentioned the white Harrier, lordship, Tata Harrier.
That is it was the vehicle that in my name.
All right, CD.
Main irrigation lordship against the person.
So you are
who was
connected,
there
your
in the
vehicle
first
is there.
sequence. In the second sequence, I was not there, only
It
my
will have
vehicle
the
was
CD.
moved. Interim protection,
No.
I can record my.
See the CD, you will get that opportunity after that also. Yes, next. Give date.
24, 24, 24.
Right.
May I please, my lord. Therefore, my lord, PRS bail, my lord, is a petty case, my lord. So one stolen, my lord, inverter and one Nerolec, my lord, oil paint, my lord. FR is page 15, my lord. This vernacular affair. May I read this affair? ইয়াৰ দ্বাৰা আপোনাক জনাও যে শান্তিপুৰ এলেকাত থকা এপি এণ্টাৰপ্ৰাইজ হাৰ্ডৱেৰ দোকানখনত যোৱা নিশা 24 তাৰিখে চুৰি হৈছিল। ৰাতিপুৱা দোকানখন সোমোৱাত দোকানখন খোলাত দেখা পাইছো। Now, this as FIR lordship, the case was registered. The theft is required. Now, this other accused person, there are two accused persons who were arrested, lordship. They are in possession of stolen articles, one inverter and 1 liter Nerolec oil paint, my lord. Now, this present petitioner not named in FIR lordship, and now, my lord, this present petitioner is a bona fide, my lord, the purchaser. The present petitioner, my lord, is carrying on the scrap dealer, my lord. So, this is my humble submission, Your Honor. Will cooperate investigation, lordship. Today's time may be allowed, your lordship. License is page 10, lordship.
Who knows? You may be their regular customer. They are regular thieves.
No,
They
my
keep
lord. No, my lord. That's
killing, they
page
keep
17.
telling.
Say,
No, we'll have
page
to see.
17, page 17, may I request, my lord, page 17, my lord, page 17, it is clearly, it's mentioned,
What?
page 17,
You are
clearly
clear-
mentioned.
you are clearly mentioned in the forwarding report.
Yes.
You are a
Yeah,
receiver
I
of
have
stolen
no receiver,
property.
my lord, I have annexed the
Who knows?
license, my lord.
Who knows?
No, my lord, already recovered, my lord, 1 liter oil pan, and now, my lord, 1 inverter battery, my lord, already recovered, my lord.
That is only what is recovered.
And now I am the trade license holder, my lord. I have annexed the trade license, my lord.
Everybody needs to have a trade license.
No, my lord. Being as I am this carrying on business, my lord, scrap damp, my lord. And it's already recovered, my lord. It's my campus, my damp already recovered, my lord. Nerolec oil pen and my lord, inverter battery, my lord. At least, my lord, 2 weeks or 3 weeks or 1 week's time may be allowed. Investigation will cooperate, my lord. Already my statement recorded, my lord. May I request, my lord?
But already recorded.
Already that time statement recorded, my lord. The recovered time, my lord.
Then
My lord.
you are not arrested. Then you have no
my lord.
apprehension.
Now, my lord, police anytime, my lord, threatening me, my lord. At least, my lord, cooperate with investigation, my lord. Time may be 1 week's time may be allowed, my lord. My statement may be recorded, my lord.
If you are not arrested at that time, then at
No, my
present
lord.
you have no
Anytime, my
apprehension.
lord, threatening, my lord, police charge me my house, my lord. May I request, my already recovered, my lord. It's a pretty offense, my lord.
He's outside, Lord.
Nerolec oil
He's
pen.
outside.
No, it's the case of the Jorhat, my lord. At least, my lord. If prayer, my
We'll see the CD.
no, my lord, may I
No,
humble
please.
request, my lord, at least consider, my lord. 1 week's time may be allowed, my lord. A humble request, my
All right, we have considered the request and decided. Yes. Next case.
Deeply obliged, my lord.
Got it.
Okay. FIR at page number 9, investigation regarding FIR lodged after 4 days of in- for the knowledge of the petitioner. Sir, is the accused number
FIR page?
is 9, Lordship.
9.
Type Panagula is 12, Lordship. Petitioner is accused, but in accused for 1 and already arrested.
It is required, Lordship.
Yes, PD.
Short date.
Everybody needs a short date.
312.
Your Lord. Well, as a previous bail application in a charge sheeted matter, my lord. My lord, I had no knowledge that there is a case of 366 against me, my lord. My lord, when someone has come, my lord, I moved a petition before the under additional session judge for previous bail, which was rejected on 25/7. That's why I'm before. My lord, I am ready to appear. I do not know how. And my lord, in the FIR is so vague that
You
I
do not know there is a case and you applied for bail.
No, when I received the summon, my lord, I applied for bail. Earlier, police never came to me. A case of allegation of 366 has been alleged against me. That I have induced a woman, my lord, that is at 1 a.m. night. And the affair is so vague that how it is possible. So, my lord, I may be permitted to appear and pray for regular bail. Until then, I may be given protection. My lord. There are cases, my lord, your lordship also considered that in the charge sheeted case, period bail can be considered. Question is that I will cooperate in the trial till the end to establish the truth that I am not involved in this.
You appear there.
And give me, my lord, protect me. But
Till that time we can protect you, although nobody is looking for you now.
no, my lord, your lordship knows it is a non-bail offense, my lord, charge sheeted. I will stand behind the bar. That's why I pray for protection and I will pray for regular bail. Mr. Court.
Till then,
Well, kindly peruse the FIR, my lord. See how this case has been charged. It is submitted desperately that on 27/2/29 night at about 1 a.m., my daughter Mongoli Biswas was kidnapped by inducing love. How I went there, how it is possible, my lord? The accused is a married person and resides in an in-laws house, having permanent resident of Ramakrishna Nagar. I doubt that my daughter may be sold out. I came to know that the accused is associated with the antisocial people. As such, I do not know when the accused will sell my daughter. But so vague. My daughter is a student of DNK Higher Secondary School. And my lord, immediately guard was recovered, not from my position. Actually, in fact, my lord, we were traveling the same bus regularly, my lord, in the same locality. I am also working, she is working in another, she is a student. My lord, that way, we went to a dhaba, and it is about 7 p.m. in the evening to return to house. In the meantime, case has been filed. And she is recovered immediately. There was no induction or but kidnapping, my lord.
so let us see her statement.
And I tell lordship,
Call for the stand.
Mr. Counsel for the petition. Is stated that such it has already been submitted in the case, hence call for the scanned copy of the TCR. List again on.
lordship.
Yes.
Exactly. The second bill application, my lord, earlier occasion was alignment. Only my lord, I am putting my
PD.
And the crime page number 8. Basic allegation is that there is a theft has taken place in a shop, my lord, from valuable been taken by the unknown person. Police say after page number 8 is the FIR,
Can it-
from water taps, gas stove, and south 50 showers and 100 basin taps has been unknown. Person, one of the persons has already been arrested. Wants to cooperate with the investigation.
No, we'll have the CD first.
Some protection, my lord.
Oh, what protection in this kind of cases?
Right, my lord, I've got my statement. My
Anticipatory bail is not meant for this kind of cases. Theft of-
fix a short
12.
This is an application under section 483. Three petitioners are there. Petitioner number 1 is the father and the petitioner 2 and 3 are two sons. FIR is at page 14. Although FIR has been lodged, but petitioner not aware whether it is registered. Because but IO is frequently visiting the house of the petitioners. And subsequently, this FIR was lodged on 25/9/2025. And allegedly one incident was took place on 9th of August 2025. Allegation is that the petitioner number 1 gave a dab blow, the informant. And thereafter, one mutual deed of compromise was also executed to that effect, that the petitioners were supposed to pay rupees 25,000 as a cost of the medical expenditure. But they have already paid 10,000 also. But now they are extracting more. When
Where is the FIR?
FIR lordship will find that page 14, my lord. Basically, allegation is against the petitioner number 1. Such allegation against the 2 and 4.
Occurrence is of which date? 1st of August 25.
But actually, it ought to have been 9th of August. There is 9th of August. And fire was lodged on 25/9. And deed of compromise was executed on 17th of August. Annexure 1. Page 10.
Already. Hard learned comes. Additional PP is an application. Students. The allegation against the petitioner is petitioners is that they that due to mutual quarrel, the petitioners attacked the informant with sharp weapons and caused grievous injuries. However, the matter was compromised as the accused party undertook to bear the medical cost. Subsequently, they resiled upon their promise. Hence, informant was lodged by a call for the CD. Appears that the FIR was lodged long after the date of alleged occurrence. Compromise deed executed by the parties is also annexed to the petition. Having regard to the provided 20,000 section. List again now.
15. 10 to
Right. It is still in a period of 7 days. Current temple.
Your Lordship, after filing of this case, there is subsequent development, Lordship. Probably, Lordship, kindly see that was served with a notice under section 179 BNS. His Lordship issued to witnesses. Probably he is called by the IO Lordship as witness on 18/11/25. So in view of that matter, the present application may be closed. There is no apprehension.
Is submitted by learned counsel for the petitioner that in view of the notice under section 179 BNSS to the petition, he has no further apprehension of arrest. Accordingly, the identification is withdrawn.
Maybe
Close down withdrawal, all right, if you like that, prefer that word.
obliged.
The previous police report was called for to know the current status of the matter.
You are for respondent two.
And for the newly implemented respondent number 2, I seek fixed time to file a consultation. Some documents has not been annexed.
What police report was called for regarding service?
Regarding the status, Your Lordship,
Huh?
regarding the status of this matter, Your Lordship, this is the land grabbing matter.
What matter?
Land grabbing, where the petitioner is the lawful purchaser of the land.
I do not find anything reflected in the order calling for any report.
First order, on the first order.
Learned counsel for the petitioner. Mr. So-and-so enters appearance for the respondent number 2 and prays for time to file affidavit. Is also noticed that learned additional PP was to call for a report from the investigating officer regarding the involvement of the present petitioner in the aforesaid case as reflected in the order dated 02/05/25. But no such report is it available? Any report is there? Such is available today. List again on. What police report is to be called for? You are challenging what?
Question.
Missing of FIR. Police report regarding status of the case. On the next date, the IO will the OC Vorolumuk PSL submit a status report of the case.
Obliged.
In my lord, case diary received, my lord. Listen, your lordship may kindly take up after some time.
Case diary,
CD was earlier called for my.
Huh?
Listen,
this criminal petition.
yes, criminal petition.
Passing.
What are we going to do today? If CD is received, we fix for hearing.
Yes,
Correct. CD means what is the stage?
yes, my lord, charge sheet not yet submitted, my lord.
Learned additional PP, Mr. Bhotakur submits that the updated CD is received.
Yes, sit. No, CD is not updated up
Hmm?
to 25/20.
Not required, madam. Last. The third time that matter has come up. It did take a, because there's nothing, that won't be necessary even. I may suppose the entire company has been made a party in all are the employees. The company, my lords, that is run from Mumbai. We run the port, the Dhopri port. Some this that all the company from right from the director who was not even present that have been made a party. Hey, my lords, where is it? Page 24. ma'am.
Anyway, we can't finally hear the matter today. Miscellaneous day because we'll have to have a hearing.
May I kindly request to give a short date, ma'am. He may be retained. That's fine.
The revision is admitted for hearing. Is the matter on give a date of on a hearing day.
CD may be retained.
Yes, CD to be retained.
Needed after. Needed before. Much of it.
First of all, Lordship, hearing from respondent number 2. I need some time to find.
Miss so learned counsel enters appearance for respondent number 2 and 6. Time to file affidavit. Accordingly, list the matter again on. Give the date. interim order passed earlier to the next.
Obliged.
It already adjourned.
Adjourned, I think. 52 is adjourned.
Item number 17, your lordship has earlier granted two of the petitioner. Item number 17, my lord. I have voluminous, my lord, scan copy is voluminous, my lord. I have only earlier in two cases, your lordship has granted bail on the ground of non-communication of the grounds of arrest. Regarding the present petitioner, my lord, they also prayed for that, only on that ground, my lord, prayed for bail. So, my lord, only sometime I will go through the case, my lord, scan copy, whether, my lord, those grounds of arrest. Nice.
All right, we'll take up after some time.
Yes.
CD received.
10 copy.
None appears list in the next.
Heavily. No, to keep.
PCR received.
Matter that the there is the version 26 325 days. The subsequent matter there is the other accused bail and the appearance days, and the next there is 21/11.
Your name is?
Manoj Bodol.
Manoj Bodal.
Behind the person.
There is direct evidence against you.
That particular date when was the Rak one. And moreover, was on there as a witness the accident that had happened.
That is what you say, but the record says otherwise.
I have trademarked, my lord, those statement of Girish Nath, and why Girish Nath was granted bail, because Actually, in fact, there are no materials against Girish Nath. He actually accompanied the, my lord, deceased victim, my lord, on that day, and for which there is no material against Girish. And he is the main eyewitness. His 164 statement is also there. Because my lord, witnesses implicated that many Manoj Godlo, even after my lord, victim was unconscious, thereafter, my lord, these accused person.
Now, Lordship, Girish named here in your Lordship. He has been named in the FIR as a person who has resisted the attack. He is the friend of the victim, whereas he has applied for anticipatory bail and he has got the anticipatory bail, but it has not been mentioned under what condition and why he has applied for the anticipatory bail, under what circumstances he has been pending arrest. That is also yes, Lord. Moreover, the FIR was also not instantly filed. Your Lordship, find at the page 17, there is a note therein. Page 17, there was some delay in lodging the Azahar in view of the last weeks of the deceased, and though police went there on the day of death, but did neither interrogate nor inspected the place of occurrence. Other doesn't. Lordship, also in the while rejecting the bail application, the lower court below, Lordship will find at the page 37, has in the second para, it has been mentioned that death was due to coma as a result of injuries sustained over the head as described, and all injuries were antemortem and caused by blunt force impact and approximately death 4 hours.
So that supports the version of the witnesses. You are hitting that person on the head even after he became unconscious.
No,
Hard learned counsel for the petition.
Lordship, let him face the trial, your Lordship, he made it. But he's already
In that
behind
case,
the-
we have to release everybody in
You
in jail.
Placed behind the bar, your Lordship, he may face the trial with proper guidance to his lawyer, Lord. Other the accused
We
person,
apply there.
other accused also outside your.
Other accused person did not have any role.
Line of protection, 47 days. Cannot go and bail on.
Not when there is eyewitness account. Hard learned counsel for the petition. Additional PP. PCR as called for has been. Can go PCR as called for has been received. An application bail. The accused student has been in detention since when?
This since 26/3/2025.
If as per the FIR, paragraph 3, perusal of the code, it appears that there is sufficient incriminating material regarding the direct role played by the accused petitioner in causing the death of the deceased. Having regard to the gravity of the offense, the material available against the petition, the prayer for bail stands rejected at this stage.
All right.
Item number 20 and 21.
I am not pressing my lord, item number 20, my lord.
Item number 20.
Same accused, my lord, in both cases, my lord, two different PS cases. One is Silsor and one is, my lord, Dholai PS.
Learned,
And item number
Pursuant to
20.
learned counsel, petitioner submits that he is not pressing
Item number 20, my lord.
the present application. Item 20 accordingly dismissed as withdrawn. Item this is dismissed as withdrawn.
Item number 21, my lord, charge sheet submitted in the.
My lord, the case, my lord, cannot be submitted, my lord. Please,
21.
This my lord failed to apprehend actual culprit just to show my lord formally they were arrested. Page 4, my lord, paragraph, my lord. They were going to medical college, my lord. They have arrest, my lord. And they are, my lord, uncle and my lord, nephew, petitioner number 2 of petition number 1. They have stated, my lord, they are not all in. More than, my lord, they are, my lord, languishing still since 3/9/2000. And arrest, my lord, bail order also, my lord, rejected, page 20, I have annexed, my lord. As per allegation, my lord, bail order of the honorable court, trial court, my lord, there is also nothing specific against them. Page 20 and 25, honorable, my lord, session judge passed the order. No specific.
Yes, PP.
Yes. The city charge sheet submitted, ma'am. As per my
Oh, so CD is not here.
Since, my lord, 3/9
Hmm?
since 3/9/2020, they are in.
3/9, you shot somebody on the head.
No, my lord, they have stated, my lord, the lordship kindly have a look, my lord, they have stated, my lord, actual culprit they have failed to arrest. And they are going to, my lord, they are, my lord, another district from, going to medical college, my lord, from the, my lord, road they are picked up. Not at all, my lord. My lord, order of the, my lord,
Anyway, we have to call for the TCR.
Yes, ma'am.
kindly, my lord, considering the bail order, section order, lordship, page, lordship. There is nothing, my lord. Sufficient time they have spent, my lord, apartment.
The criminal antecedent is there. Item number 20 also, same accused person is involved, madam. In Silchar case.
Yes, it is submitted that charge. It has already been submitted, hence call for the scan copy of the TCR along with the case diary list again on the date.
Kindly, what are they? Come. They are not equal. Just formality, my lord, they are.
It is a short date.
Kindly,
It is the short date, but if you given,
One.
yes, then how much shorter can it be?
17, my another, my lord. Kindly, come, my lord. Let us try, my lord.
Cannot accommodate every time.
Sufficient time, my lord. Therefore, my lord, I am, my lord. My lord, 9. Charge sheet is also submitted.
Otherwise, my registry has to, my lord, call for the scan copy of the. Again, my lord, fixing before 1, then again, scan copy will not come.
That is the reason. Or you obtain certified copy and submit.
28, my lord. Oblige.
May please, your lordship. PCR was called for in this case, lordship. Here, madam,
TCR receipt, my lord.
Yes,
Mainly on the ground of arrest, my lord. This is the non-compliance of the 47 and 48 notice. My lord, I have flag marked the, my lord, that is the forwarding report, my lord. Not forwarding report, my lord, that is the order, the date of the forwarding of the, my lord, in the TCR, my lord. Horizontal flag mark is there. No, not report, the order passed by the TMS. 23/5/25, my lord. The record in the first.
which one? Flag mark A. What is flag mark A? Horizontal flag mark not finding.
Maybe. দিয়কচোন মই দেখাই TCR
TCR.
on horizontal flag mark. Relevant portion I like.
Does not say anything has been communicated in writing.
My lord.
Does not say it has not been communicated in writing.
That part is not there, but my lord, in the later part, my lord, when my lord learned JMFC, my lord stated that he was asked, my lord, and he informed that, my lord, that is to his family also, he is known about the fact, and also to his family, my lord, that is communicated, my lord. Thereafter, my lord, JMFC, my lord, make this, my lord, that is point that, my lord, that is the Kumar is followed, my lord, in the order, my lord, which is reflected.
Yes, Lord. Most recent case also, Rajesh Sabhat,
Mihir
Maharashtra.
Mihir
Supreme
Rajasthan
Court has-
case, my lord, that is the Worli hit and run case, my lord, where, my lord, that was pending, my lord. But there also, my lord, if we go by the Mihir Rajasthan, then, my lord, from the
Right.
date of the pronouncement of the judgment, because on that, my lord, categorically stated the word henceforth. Earlier in, like, my lord, in that is the case of Pankaj Bansal, the word henceforth is there. Now, that is the recent case, Mihir Rajasthan, where the word henceforth is there, my. Then, my lord, it is not applicable in this case. If we'll go by the Mihir Rajasthan case, my lord.
Rajesh, the case also, writing written has to be given, it is category. Has been interpreted by the. Yes, otherwise we have annexed our notices on 37 and 38, Lordship. New case, Lord. Only 178 days. Even the 35 notice was, arrest memo was also violated where the signature of the attesting witness is not there, Lord.
We'll have to examine the record.
My lord,
We'll have to examine.
my lord, my lord.
What is the citation of Rajesh?
Mihir Rajasthan, my lord, is station, my lord. We have, my lord. I am sending it, my lord. That is in the.
All right.
And my lord, may I read the only relevant para, my lord, because I am stating on that part, my lord. Otherwise, everything is, my lord, that is.
They pass over the matter. But today matter may be pass over. I will have
Today. Why not
I
say
will
that in the first?
bring relevant judgment. Yes, with relevant.
All right. Asked over for the list again on. You submit it anyway.
Yes, my lord. I mean, while I am Mihir Rajasthan.
When do you want?
State, Lord. Later. 22. 23.
Sunday.
Yes,
Yes, next
25.
case.
20. Obliged.
Yes,
Yeah, the CR and CTS.
received.
Yes,
TCR receipt, my lord. With me, madam. Order.
Your Lordship, I was arrested on 2/11/2015, pursuant to the case, and Learned Session Judge granted me bail on 10/12/2000. Charge sheet was submitted on 29/1/2016. Thereafter, Your Lordship, I kindly peruse Annexure 2, page number 17, where I was absent with steps. Then again, on Annexure number 3, that is 16/12, I was absent. Now, here, Your Lordship,
You are Salim Ahmed.
I'm Salim. Due to little miscommunication regarding the engagement and accommodation of my learned counsel at trial court and pregnancy of my wife, I had to visit the hospital. I could not communicate. I was absent on that. Next day, NVW was issued against me. Again, I was absent. Police could not find me. Because I was back there in the hospital. And then on the third date, because of my absence, proclamation was issued against me. On the strength of proclamation and NVWA, police arrested me on 25/7/2025, Annexure 8, Your Lordship. I was produced before the Learned Session Court below. And since then, I am behind the bars, which is more than 130 or 135 days, I mean, on the date of arrest. And my other co-accused also, they were also arrested on the strength of NVWA. They were granted
Bail by
bail by the concerned court, Learned Trial Court, that is Additional Session Judge FTC Shribhu.
what about your case?
My case, Your Lordship, my bail has been rejected 3 times. And for subsequent development, one accused person, Ashik Ali, he has not been arrested since the inception of the. He is evading arrest. Till today, NVW proclamation whatsoever has been against but not been able to arrest. So my humble prayer, Your Lordship, that since I'm absent, I accept my absence, but I was never absent without steps. My learned engaged advocate used to submit the concerned petitions with court marking absent, which was always allowed to. Only one day I was absent without step because I went to the hospital with my wife. And thereafter, the next day, I was again absent because of that little miscommunication. Court issued NVW. Police did not find me 3 times in home. And for your information, Your Lordship, that proclamation was nowhere placed in any conspicuous place near my village, or my village headman was also not informed. This is the principle of parity, as well as marking the period of detention with more than 100 days, considering the alleged offences in case. Because I am ready to face the trial. Your
Where is your order granting initial bail?
Your lordship, that has unfortunately not been annexed here, but the date is, it is there in the trial court record. Date is 10/12/2015. Apology for, I could not get the certified copy. Dated 10/12/2015.
10, 12,
2015.
1, 5.
1/5.
I have only flagged one order, my lord. Kindly peruse that, my lord. The fact is that, my lord, the accused petitioner appeared, my lord. When, my lord, the summon is issued, thereafter the steps come, my lord. He appeared on that day that, my lord, that is submission is also there, that, my lord, he was not able to, my lord, that is get the COT at that point of time. So, learned, my lord, that is the JMFC, my lord, then filed, my lord, stated that, my lord, on that day he was allowed, my lord, so that he should be in the earlier previous. That order may kindly, my lord, see. And it is a case, my lord, when PNA issued, my lord, on various opportunity is given, my lord. He has every, my lord, that is the information he has, whatever may be there. Now, before this honorable court, what he stated regarding the pregnancy and other part, he can, my lord, make this submission there. And it is not a fact that, my lord, that is the learned engaged counsel didn't communicate the same. Because this order reflects that he was very much present on that day, my lord.
May I please your lordship, on the humble submission of my learned senior counsel here, order dated 2/11/24 clearly states I am absent with steps, which was allowed. The next order is 16/12/24. WA was issued against me because I was absent without steps. That is my question. I was not present on that day. I also informed my advocate, but that is a different case. That is not my concern. What happened with me and my advocate. Then on 14/2025, NVWA was again issued because it returned unexecuted. I was found absent. I accept that I was absent in my home because I was there in. And the date of delivery of my wife, which is Annexure 12, your lordship, 25/2/2025.
So the case was basically pending for Asik Ali.
Yes, your lordship.
Because all the orders reflect that he was absent with steps and one accused was absconding. So case just continued that way without progress. Till 2/11/24, he was either present or absent with steps.
Madam.
is on 16/12/24 that he remained absent without steps, and then
My lord.
and interestingly, NVWA was issued, but on the next date he was absent with steps again. (14/2/25). So and Salim Ahmed are absent with steps.
Yeah, my lord,
Issue
that is the
press and
petition, my lord, it is my lord long pending from, the last is my lord, when my lord PNA issued 16/8/24. 16/8/24, page 32, my lord. And before that, my lord, WA is put on my lord 12/9/23, 14/7.
No, so it appears that
My lord.
he has been appearing with steps since the year 2015.
15, my lord.
It is only in 24
15,
that he
now 20.
defaulted.
Yes, but that's true, my lord. That's
Already heard learned counsel for the petitioner. So heard learned additional decision application under so and so. Now, it appears that from the TCR that the petitioner has been present or absent with steps in the aforesaid case since the year 2015, but it is only on (16/12/24) that he remained absent without step, whereupon NBWA was issued against him. Pursuant to which he was arrested and remanded to custody. His subsequent prayers for bail were also rejected by the learned court below. Where it is submitted that the petitioner, due to the pregnancy of his wife and miscommunication with his counsel, defaulted on one day, because of which he has had to suffer incarceration for more than 100 days till now. Although the case is pending due to the abscondence of other co-accused, namely Asik Ali. Where having regard to the above, it is provided, directed that the petitioner so and so shall be released on bail of rupees 3,000 to securities of like amount to the satisfaction of the learned trial court. This additional session judge FTC Sri Bhumi, in connection with foresaid case, it is further provided that the petitioner shall regularly appear before the learned trial court. Petition stands disposed of accordingly.
deeply obliged. Two of 1/4. Did you not?
I'm behind the bar for 32 days as on date.
Only
Per page 11 law.
all right, next week.
My lord, my lord.
21 lordship and 21st time.
হাইডি গলে
Right.
এইখন কোন কোট আছিল চাব
Right, please, your lord. That's it. Your lordship, you find page 9. Wife committed suicide, lordship, after 17 years of marriage. after in-laws filed the FIR and he was arrested. In the FIR also, your lordship will find that information about committing suicide is there. But FIR was registered under section 1031 initially. Subsequently, lordship, during investigation, they found one suicide note, and your lordship will find in the forwarding report, they quoted that part, lordship, page 18 is the relevant portion. That ground number 6, they recovered on suicide note, which lordship stated that the accused was having an extramarital affair, for which the deceased went into depression and committed. That is the content of the suicide note. I am relying on a Supreme Court judgment, lordship, which says, lordship, that if husband, lordship, having a extramarital affair, that cannot be, lordship, ground for conviction under section 306, that is now 108. That 108 is subsequently added here also. That, but in my certified copy, which I have obtained recently, there is no mention, but my learned friend can say from the case diary, lord, that 108 is added on. That is mentioned in my rejection order also in the sessions. Page. I have subsequently paid for adding one. Side note is also there regarding. And already lots of 82 days as on payload. I pray that considering the length of detention,
What is the PM report? Suicide?
The PM report is not conclusive regarding cause of death, my lord. Thereafter, my lord, one FSL report is also there as per my lord, FSL report. That FSL report only stated that no poison was found in exhibit shown. Regarding exact cause of death, my lord, there could not be ascertained from that.
No, what is the column neck?
Regarding my lord,
Is it suicidal hanging or anything was there?
no, my lord, nothing is there, but injury marks is there. Injury number 1 and 2 were antemortem and caused by blunt force impact. And
What-
regarding the aspect of my lord 108, your lordship, one vital witness, that is 15 years daughter of the my lord, this is our witness is important regarding my lord continuous mental and physical torture, my lord, how brutally my lord the accused person my lord tortured, my lord, that is his own daughter, my lord, 15 years.
108 lordship, he is already more than now as on today. He is on.
PM report is here.
Yes, PM report is. I have track mark. 2 injury marks is also there.
Submission of your Lord, that so that which is registered under section 103 for committing murder, Lord. Probably that section is not reflected in the patent.
Hmm?
That the case is registered under section 103. Probably that section is not coming. And 498A or 106, he has already spent lots of 82 days in custody, Lord.
No, the allegation against you is you are the main accused, and the final cause, final report regarding cause of death was kept pending for FSL report. FSL report shows no poison. So cause of death is naturally because of the injuries.
But your
So
lordship may
if it is
kindly
not 103, what is it?
Precise notice.
108 also added, my lord. If 108 added, then also from the statement of the my lord authority victim, how my lord continuously, my lord, my lord physically, mentally tortured the victim, and which also corroborates, my lord, the injury report of the postmortem injury, my lord, that marks in the postmortem report. That case also, my lord, although cause of death, they are certain at this stage, but
Side note
those
says he
evidences
committed
specifically,
suicide.
my lord, pointed
And
out
the
that
length
he is
of detention,
involved,
lordship, 82 days as on today, Lord.
also tortured, my lord, physically assaulted me.
For collecting that postmortem report, probably his custodial interrogation will not. That is my humble.
There is ligature mark on the neck, so possible that it is a case of suicide.
Yes, and
Well,
otherwise her suicide note, regarding her suicide note also, he stated that because of this, my lord, matrimonial dispute, my lord, because of some illicit relations, he committed suicide. Regarding that aspect, my lord, therefore 108 already added. In that case also, my lord, continuous physical and mental torture, because of which he ultimately, my lord, she ultimately committed suicide. Regarding that aspect, my lord, evidence is there, my lord, that witness of 15 years, his own.
Okay, we'll examine.
Regarding that extramarital affair, also, I have given that that is on paragraph 19, Lord, all paragraph
Para 19.
19.
Prima facie, it seems that although cause of death is not, my lord, there in the case, this is a case of suicide. This, my lord,
This may not be the only cause.
only.
So 108 is added, therefore I am obliged, Lord.
Bars last 35 days.
P3, my lord, CD note. Kindly demonstrate.
Hmm?
Because one of the applicants, a stable person. My lord, kindly peruse the page 24 for a moment. I have appended
No,
the.
just let us first see what is the allegation.
Yes, my 71, my lord. Gang rape.
Hmm.
My lord, may I kindly have the FIR at page 13. One. May I read, my lord?
Yes.
On 5/10/25 at around 6 p.m., I was coming from other people's house towards my house when the accused found me alone in a deserted place and gagged my mouth and took me to a nearby bill and forcibly raped me. Later,
All right, 24.
deeply obliged.
To communicate. Yeah.
Please, Your Lordship. Clearest bail application. Then petitioner was on interim on 28/5/2025. Thereafter, the petitioner has recorded its statement. Case diary arrived on earlier occasion. Up to date case diary was complete.
Updated.
CD receipt. His statement is also there. I will point out. His statement is also available.
May I go through the FIR on page 11, Lodge? Lodge has got the FIR.
Yes. Yes, go on.
May I read, Lodge? With due respect that the above name accused made a agreement on 5/6/2004 and away Mahindra Bolero car, register number so and promising to pay rupees 28,000 per month as for rent for 3 years. I have hand over all the necessary document to him after made an agreement. The above name accused was paying rupees 8,000 per month as rent for about 6 months. After taking the car from me, however, he did not pay rupees 28,000 monthly rent. For last 7 months from today, I could not reach the phone when I came that he was in Central Jail. Therefore, I met him at Guwahati Central Jail. At that time, he has no contact with the people where he had rented the car, so cannot return the car. Then I tracked the location TPRS, found out that my vehicle is Tripur. After that, I went house several bucks for my car, but he returned and other took the clothes wearing and threatened to file a false case against and jail. I would like to mention here in the agreement and vehicle from my father's dust, Mahindra Bolero, Tipsoikia Mahindra Bolero number relative foreign Tata Yodha when the vehicle has not returned and
So what has he said in his statement?
Yes, his statement, he has stated that, my lord, at that point of time, he was in Central Jail. So, my lord, your lordship, before stating that, your lordship, I would like to point out page 8 of the paragraph 9 of the petition, the present petition. He is at that point of time, my lord, already in jail. Regarding that, why he obtained bail, that bail order is also annexed. I will point out to your lordship. Your lordship may kindly first come to page 6, paragraph 9 of the petition. Present. That the petitioner begs to state that he has also rented the above mentioned vehicle to other people, but after he was arrested by the crime branch police, he has lost contact with those people. Since his mobile phones are seized at the crime branch police station, so the pending money and the cars will be returned as soon as received his mobile phone. So this is the statement in the case diary also. And why, my lord, he was earlier arrested, your lordship, that order is annexed at page 17. Your lordship may kindly come to page 7. Regarding other materials, I will point it out. Page 18, my lord, relevant paragraph, my lord, 3, my lord. It is to be noted here that above noted case has been registered. That is other case, my lord, regarding.
You got default bail.
Yes, default bail, my lord. What the offense, my lord, he has committed, I am just saying. Basis of an FIR lodged by one Mohammed So-and-so of Rajasthan on 13/11/24. The essence of allegation against the present petitioner is that by misrepresenting himself to be an employee of the National Investigating Agency, NIA, and using NIA logo, he promised to arrange 8 vehicles from NIA auction. And on such claim, the informant had transferred him a sum of rupees 32 lakh by online in between February and so and so. However, only one vehicle was delivered to him with proper legal document and when he visited the court. So, my lord, modus operandi of the present petitioner in the same manner, my lord, he thereafter, my lord, taken vehicle on rent, thereafter sold this vehicle to other places. In some of the vehicles, he is in Manipur.
That is a different case, Lordship.
Uh,
May I
di-
submit in this
Different,
case,
but
Lordship?
I am pointing out the criminal antecedent of the accused person, my lord.
May I submit?
And regarding the present case, this is anticipatory bail. Although he appeared before the IO, my lord, otherwise considering these criminal antecedents and this type of offences, continuously he is involved. My prayer before lordship, at this stage, considering the materials not a fit case for granting anticipatory.
May I submit? Lordship, in this case, Lordship, in the present case, Lordship, he was already paying a certain amount that has been mentioned in the FIR also. For last 6 months, he has been paying sum of rupees 28,000. Thereafter, he went to judicial custody. And his phone was also seized by the crime branch. Thereafter, he could not take out the phone after it took 3 or 4 months. to take
Judicial
out
custody in this, in the
other
case in
case,
which
other
he was
case.
granted bail.
In which he was granted bail.
Granted bail on 2525, till now, those vehicles not yet.
No, not on 2.5.
Yes, 25.
10.3.
Not 10.3.
10.3. Thereafter, Lordship, after he has been granted bail, after recording of his statement, 2 of the vehicle has already been recovered. And he has, after recording of the present petitioner statement, and other 2 vehicles are in the Manipur. Because of the ongoing situation in Manipur, the petitioner could not visit Manipur to bring those vehicles back. Otherwise, he has been paying to compensate the present loss of the complainant. He has been paying money, the 28,000. Lastly, he has also paid on the month of October. He has paid the rent, and he will be paying until they have mutually decided that he will be paying. He has already recorded statement, and upon recording of his statement, the 2 vehicle has been recovered, and other 2 is there in Manipur, and he is ready to cooperate. Earlier case was a different case, totally different. This case is ready to cooperate, and he has already paid, and he already 2 vehicle has been recovered after his statement is recorded. After the petitioner has leaded.
Order dated 28/25. 1, 2, 3.
His statement is available there.
Ready to abide by any condition whenever it is possible. Stringent condition to be imposed that the petitioner will abide by. Ready.
To Paratin. It is it appears that previously the petitioner had been paying the installments for 6 months after entering into the agreement with the informant. But subsequently, because of his arrest in connection with the aforesaid case, connection with cyber branch PS case number 17/24. He was not in a position to repay the loan amount. After being granted bail by order dated 10/3/25 in PA 253/2025 by this court in the cyber branch PS case number 17 of 2024. he had paid further amount rupees.
Directly paid to the complainant. Name is
This is 25,000. You have given 2 copies, or is it 50,000? 55,000.
one transaction.
One
25.
transaction only. 25,000 online. 0809/2025 to the government. And further pursuant to interim protection granted in the present case by this court, he has appeared before the IO and his statement has been recorded. He is also submitted that subsequently 2 of the vehicles have been recovered. Where mobile phones are still in Zimma, not yet granted.
It was granted Zimma.
After granting of Zimma,
After granting of Zimma, he was able to communicate.
were recovered after he obtained custody of the mobile phones, because of which he could contact the person to whom he had given the vehicles on rent. Having regard to the above, and the fact that the petitioner has been cooperating with the investigation, as far as the present case is concerned, his custodial interrogation not be required. Accordingly, prayer for pre-arrest bail is allowed. The order of interim pre-arrest bail dated 28/5/25 is hereby made absolute upon the same condition.
Earlier, the case was registered on Koliabor PS, but later on it was transferred to
The Koliabor thereafter transferred to Zurabad, and finally, my lord, this is Dispur PS 524/20.
because of the
The
jurisdiction.
second paragraph 2 after Koliabor PS station, and presently Dispur PS case number
524/20.
under section, same section,
Same section.
paragraph 2 to Silok. Ordered it.
Deeply obliged.
Victim site has already appeared. First of all,
Yet, my lord, case diary not.
They did not receive
Here,
list again. No?
several dates bail. In fact, lordship, in one date came. Subsequently, on that day, lordship, service was not completed. Another day was on that day, lordship.
That's when Hardman counsel for the petitioner had learned additional PP submits that CD has not been received. It respondent number 3 and 4 are represented by their learned counsel. It appears that despite several orders, the CD has not yet been submitted by the IO. Hence, the IO is directed to submit the CD positively by the next date fixed. List again on so and so interim order passed earlier to continue till the next date.
Lordship, interim is not there. Lord.
Huh?
I am paying for.
Interim is not there.
Not there, Lord. I am paying for.
What is the allegation?
And although allegation.
Earlier rejected by,
No.
Earlier rejected.
No.
no, well. Right. POSCO is also there. my lord.
There, but POXO is not against the present petition.
Okay, give it on Friday. Where is it from?
From
Goalpara.
Goalpara.
Yes, Friday.
Yes.
May I please? It's for your lordship. Community service. We are on interim, your lordship. Interim order passed on,
So what is the case about?
this is, about, on the,
302.
yes, Honor, on, 9/11 to 14, your lordship. Sujata Das, Ojan Jahar. After 10 years, charge sheet was. And accordingly, we appeared before the trial court. Court. We appeared before the trial court and, did it.
Then
Then, it, after 10 years, this, Your Honor, such sheet was submitted. On that such sheet was Annexure 4, page number 25.
what is the issue with him? If he appeared and granted bail, what happened?
Honorable Court order dated 19/9/25, they have appeared as or as per the order dated 8/10/25. They have appeared. Granted bail. 8/10/20.
You've gone through. What is the material against him?
It is injuries, lordship,
Hmm?
antemortem, lordship injuries caused by blunt.
What is your name?
Ali.
Hmm?
Allah.
R. Ali. Huh? No.
Him Das.
Osim Das.
Oshim Das,
Five,
Nathan Das, Babita Das.
6 of you.
yes, sir. All family members, sir.
Hmm?
All family members, sir. My humble is to
Hmm?
my humble submission is to salute the bail order.
What else can your submission be?
Your Honor, after 10 years, charge sheet was submitted on 31/24, charge sheet number 5 of 2024. Charge sheet, the on
You were not arrested.
Not arrested, Your Lordship. The charge sheet was shown on charge sheet, the petitioners are shown absconding. Whereby police never called the petitioner for any questioning about the alleged offense or properly investigated the case and filed the search. No, fulfillment. That the learned subject subdivision of Mr. Kasar Silka took cognizance of the case against the accused person on 11 to 24 and issue summons to the accused person.
No eyewitnesses, I think. Heard so and so learned counsel for the petition. Petitioner. Dated 90. Two. The allegation briefly put is that on 19/10/2014 at around 9:10 p.m. when the younger brother of the informant was returning from Silchar after work, the accused persons assaulted him with deadly weapons and caused grievous injuries to him. But upon hearing hue and cry of the nearby persons, the accused fled. And as a result of the injuries, the brother of the informant died in hospital. The case is of the year 2014, and the charge sheet has been submitted on 19/10/24. That is after about 10 years. Where I heard submitted that during this period, police never came looking for the petitioner, but submitted the charge sheet showing them as absconders. I have perused the CD. And it appears that there is no I witnessed the incident. Where, having regard to the fact that the charge sheet has been filed long 10 years after the lodging of the FIR, during which period the petitioners were at liberty, comma, and also having regard to the material available in the CD, is not necessary for the petitioner to be taken into custody. Accordingly, is stated that petitioners in the of their arrest in connection with the aforesaid case will released on bail of rupees 50,000 each with one security each make amount to the satisfaction of the testing of public court. The event of their arrest broke appearance. It is further provided that the petitioner still regularly appear at the trial if one commences allowed.
This is its charge lordship against the petitioner as well as their co-accused. The affair is at page 12. That is at
Earlier, I think here there was interim. Earlier case interim was there. 1 minute sound record.
Interim was there, Lord.
Interim order passed. Steps. Go to interim steps. Yes.
Your lordship. Lordship, page 12, the trial. The receipt of the affair, the police investigated the case and filed charge sheet law.
Hmm.
In the affair, lordship, my attribute is explained to the extent that under my instigation, two of my employees assaulted the injured lordship, who is the friend of the informant. Accordingly, the affair was registered under sections 1182 grievous hurt, 109 attempt to murder, and 350. Thereafter, what happened? The other accused persons were arrested, and I was called by the police for notice under section 35(3) to 35(6) PNL. And accordingly, I appeared. Page 18 is the notice law. Page 18. Accordingly, I appeared and undertook to cooperate the testing. Subsequently, on 21/1/2020, the charge sheet was filed, wherein it has been reflected at page 21 lordship, page 25, 4th line law, page 20. Status of the accused.
Yeah.
Issued to be under section 31 5, it should have been 3 to 35(6) BNSS. That means I'm not an absconder. Subsequently, what happened? After being charge sheeted law, I could not appear as there was the apprehension that I may be arrested or detained by the court or remanded to the custody because case is purely tribal by section. So in view of that, I did not appear, and this resulted in influence of NBWA against me law by the Learned Chief Judicial Matter. That is at page 39.
the type copy is at page 37 law. Right order date is 6/8/25. And accordingly, this petition was preferred under section 480 of BNS. Wherein this honorable court was pleased to grant hearing that in the event of arrest, so they will release me. On 22nd 9/2025 lordship, I produced a copy, furnished a copy of this order before the honored court below, and the court was pleased to case the fixed for appearance P12/25. That means no further NBW has been issued against. Now the case is purely under the control and jurisdiction of the land. No warrant is pending against. My prayer in the that I may be allowed to go on bail on my appearance, because I have never absconded. I have complied with the order of the investigating authority. And the FIR also does not attribute any serious allegation against. May I read the FIR? Respectful submission is that I hereby inform you that my friend Inamul Haq, resident of Swansea, has a car repairing shop, namely Swansea Motors. A quarrel broke out with adjacent car shop owner of car utility regarding cleaning by broom. In this quarrel, the owner of shop, namely Utpal Bora, I am Utpal Bora, lordship, instructed his two employees, namely Ravik and Chiku, to assault my friend. Thereafter, Chiku caught hold of two hands and Ravi cut the nose of my friend Inamul with sharp knife and cut on hand, neck, and legs. Friend is under treatment in due course. The said accused person says post it to demolish the shop. This is the allegation.
Hmm.
And I have cooperated in the question. So due to only technical reason, lordship, as the section 109 is session. So I am apprehending that on my appearance, this CGM, learned CGM, has no other option but to detain me than to custody. Will appear before the court on 3/12 lordship.
Already heard learned counsel for the petitioner, heard an additional PP. Is an application. So the allegations against the petitioner, briefly put, is that on 31/8/24, a quarrel broke out between the employees of the shop of the petitioner and the informant, as a result of which the informant, Inamul Haq is the informant, right?
Inamul Haq is the injured law.
Informant also.
No, informant is his friend Rahul.
Is the instead of informant, right, injured. Which the injured Inamul Haq sustained injuries, and in this regard, an FIR was lodged. The aforesaid FIR was lodged, resulting in registration of the aforesaid police case. Further stated that pursuant to notice issued under section 35 (3) BNSS to the petitioner, he appeared on 3/1/25 before the IO and cooperated with the investigation, and he was allowed to go. Subsequently, the charge sheet was filed. Under sections.
Understand, these are the 118(2), 109, subsection is given, and 351(2).
Slowly, charge sheet has been filed under sections
118(2) plus 109 plus 351(2) plus B within bracket 5 of B.
it is submitted on behalf of the petition that since the charge sheet included Sessions tribal offences, it was apprehended that upon his appearance before the learned magistrate, he may be taken into custody. And therefore, he had filed. Therefore, although he had taken steps through his learned counsel, did not appear before the learned magistrate, resulting in issuance of NBWA against Para is submitted that petitioner is ready to face the trial and desires to appear before the learned magistrate and seeks protection in this regard. Having regard to the fact that the petitioner was not arrested despite his appearance pursuant to notice, and also having regard to the nature of the allegation, provided that in the event of the appearance of the petitioner before the learned magistrate, he shall be released on bail of rupees 50,000 with one surety, the satisfaction of the magistrate in connection with the efforts. Yes, it is further provided that the petitioner will regularly appear during the trial if one commences. Bail petitions allowed accordingly.
Deeply obliged.
Charge sheet submit.
Yes.
Very kindly paid action. Lordship.
It is submitted that charge sheet has already been submitted, hence call for the scanned copy of the TCR. Please again on.
This case, CD was called for, my lord. I'm on interim, my lord.
Charge sheet submit.
Same order.
Obliged.
Make it not.
It is.
Here is bail application. Para pays bail. There's another person tried to sell a fake gold boat, the informant. But on my instruction, the transaction made the account of one Saddam Hussein, my lord. Was eventually arrested, 10,000 deposited in his account, he was arrested, subsequent was released on. But transaction, nothing was from our. That is the allegation is that 10,000 account Saddam, remaining amount 8 past, my lord. They provided a fake, my lord. Later on, fake.
Lordship, please.
35 is what.
This is statement of
Quick, Saddam
Wait,
Saddam Hussein.
Quick. Was arrested.
What about the money?
Money 10,000 was only paid money. 1,000 was paid to Saddam, but he was arrested. Informant had exaggerated money. Another a person, not know anyone, why he shall pay such amount to other person. Not know a person.
But he says took my bag containing 9,50,000 in cash from me.
But my lord, there was no bag actually, as per my instructions. And 10,000 was paid, my lord, on to the
We'll have to go through the CD then.
lordship. Lordship may go to the oblige your lord.
did he not receive, Lordship?
Kindly make way for kindly hot date.
On,
Alright, give us short date.
on, 3/12. Same prayer, Lord. They did not.
Wrong date was given first time. Short date.
Short date this time.
3/12. 3/12.
For second আগৰ order যেটো he did not receive.
Amicus. It's
Lordship, I'm appearing on behalf of Micus Cure, S. Nawaz. Lordship is on his legs in another court. And maybe take
But as prayed for well and counsel for the
6 for orders, Lord.
list again on.
Lordship.
Much.
The service is also completed, Lord. Office note 26/2025. It is returned. Earlier, AI was filed, even though notice was served, but they did not appear, respondent number 2. And here, this is NI, is the record also come. Record also come.
The amicus,
Should be admitted, should be for admission, Lord. And hearing.
no, it's earlier it was not complete, is it? Service was not complete. Now it is complete.
Yeah, yes, Lordship.
Huh?
Yes,
As per office note.
yes, Lordship. It is completed.
As per office note dated 2/6/25, AD card for respondent number 2 has been received. Hence, service is complete, but none appears for the respondent number 2.
Yes.
Accordingly, so and so is appointed as amicus to represent the respondent number 2. Copies be served upon the newly appointed amicus. Is the matter again on?
Yes, Lordship.
Hmm?
Check bounce case.
So,
Check bounce,
so,
not anything, because I'm not opposing to that part.
then why are you speaking at all? Is the matter again on?
It will. Yes.
Per office noted in 11.
Hmm?
Per office noted in 11/20.
Yes.
Service number. Served in 8.
What is the matter about?
No, he's a pharmacist by person. While he was performing his duty, lordship, his personnel stopped him.
Washing of FIR.
The crossing of FIR, lordship.
Who is the informant?
Respondent number 2, lordship.
He is a police person.
Lordship.
You can represent him. As,
Name.
as per office note dated 13/11/25. The consignment report has been traced out, which indicates that the item was delivered to the addressee on 18/8/2025. There it appears that the respondent number 2 is a police constable. And he is the informant who lodged the FIR. Therefore, he can be represented by the State Council. Hence, is the matter for admission. On, give a date.
For office not dated 11/11. No service in respect of
As per office note dated 20/08/25, scan copy of PCR has been received, but service on respondent number 2 is not yet complete. Issue fresh notice to District Magistrate Nagaon for service upon respondent number 2. Yes, please take again on.
Hello.
For office lordship, the court lordship, father of the measures.
I guess
Other of respondent number 2.
Sure.
What case is this? POCSO?
Yes, lordship.
Huh?
Yes, lordship.
It appears from this note that notice on respondent number 2 has been effected by serving it upon father, which notice has been placed on record. Hence, this on respondent number 2 is treated to be complete. Sir, so and so is appointed as a to represent the respondent number. Is the matter for admission on date.
April.
Please. Pass. Wait.
Hmm?
Wait for dust, sir.
Notice of on respondent number 1 has been returned back with postal remark insufficient address. Full stop. Service report has not been received back from District Magistrate Kamrup till date. Petitioner pressed for effecting dusty service. Prayer is allowed. Petitioner to effect dusty service on respondent number 1 and submit affidavit accordingly. List the matter again on.
First,
None appears to the petitioner. Service on respondent number 2 not yet complete. Await list again on.
Have the law. Here the service respondent is awaited. Here, the order dated 25/25.
Yes.
On his last part, my detected two parts. One part was that the executive, right? And second, my lord, the inter would after of service support response. During the pending, if the executive case is filed, may I sum up of 20 of this one, I will file an affidavit bringing record. Okay. My lordship, here the by the third mother upon first wife of father.
Service report in respect of sole respondent is awaited. It is submitted by learned counsel for the petitioner that subsequent to order dated 25/9/25, the respondent herein has initiated execution proceedings. And it is accordingly prayed that the matter may be taken up. But on the interim,
On the ground, I will annex this execution note filing.
in order to enable her to annex relevant documents in this regard, accordingly list the matter again on when?
Beyond 20.
20.
Yes, because for the learned file code, the train
All right, 20.
of less my lord. File you.
Please, Lords. For a moment, Lords, we kindly see order dated 10/6/2025.
PCR is received.
Not
LCR is, it is available on record, Lords.
What is-
What is available on record, Lordship, my lord.
But it is not showing in the first list.
Not so,
So we have not.
subsequently it is added on.
Hmm?
My lord, 25th of my lord September record was my lord received by the my lordship.
Hmm.
Checked with the record now. Now kindly see, Lordship.
We have gone through.
Lordship is not showing in the first list.
We'll take it up day after tomorrow, then let us see.
Lordship.
It appears as per office note, TCR has been received. Scan copy of TCR has been received. Learned counsel, learned additional PP raised for some time to go through the same. Hence list the matter again on day after tomorrow.
How like us?
Look,
Yes.
kindly pass the
Yes, and
The prayer of
and
learned
Lordship,
counsel for the petitioner passed over for the day. CD is received.
It is
CD, none appears for the petitioner. CD is received. Service on respondent number 2 has been returned unserved with postal remarks within inverted comma insufficient address. Petitioner is directed to submit proper address. List again on CD. CD is there.
yes.
CD. What do you want to do? Send it.
Turn back.
Yes.
In this case, Lordship, we have taken Dosti service.
Hmm?
In this case, we have taken Dosti service of the above test, but the time is number 30 is respects to Dosti service. So, okay, yes. Petitioner Victor is a husband. Hence, the as as a maintenance were declared by the Garnet family court. Existing also going on next date of the execution, the father of the Garnet family. There is such yes, but to
This is your maintenance.
maintenance yes. Petitioner is yes, range to we have already annexed is when he is some yes, he voluntarily left the petitioner house. Now petitioner want to return back but residing on the house, but also
So what to do?
now Lord execution proceeding then has turned back to the husband's house. This is his prayer also. He voluntarily left the
Our
house.
learned counsel for the petitioner, an affidavit of dusty service has been filed, wherein it is stated that the respondent number 2 refused to accept dusty service. Full stop. The signature of the witnesses has been endorsed on the memo of the petition of the dusty service.
The learned public is appearing, but in the court premises we have also a series. Below line paragraph
However, it is submitted that the respondent number 2 has been appearing in the family court, learned family court, where the execution proceeding is
execution
underway. Where having regard to the above, the service on respondent number 2 is treated as complete. So we'll list the matter for admission first, then we'll decide. We'll have to go through.
execution
No, on that date. On that date, we'll see. List the matter for admission on your date. Is the matter?
The present petitioner is aggrieved
Hmm?
by order dated 7/1/2023 passed by the learned Judge Zotar, whereby the said trial court to dispose of the case discharging the accused person at the time of charge hearing from the offense to IP.
You are the informant.
Uh,
although this for hearing, Lordship, we have not filed our objection.
Why not?
Lordship, can it be fixed in the next week, Lordship? Definitely, I will, the meantime, I will file.
Next week, we do not know to all, so many matters are there.
Any day.
When can it be fixed? Huh? 25.
20.
Learned counsel for the respondent prays for some time to file affidavit. Hence, list the matter again on 25.
Lordship, can it be 8? Friday,
Put
or maybe on 27th. It's a
First week of December then. No, hearing day.
4/12. Thursday, 4/12.
I think 4/12 we have fixed many matters.
Our main ground was non-compliance of section 50 and 50 of CRPC. And co-accused were enlarged on bail in, I have here and extra D on the same ground.
Next, sir.
Extra D. Case number 20.
Yes.
Case 20.
Oh, that contract killing case.
Yes,
I don't think you have complied.
yes. Regarding that section 50 notice also, I have my only section and my lord. Regarding, otherwise, he is the main accused. He is the person who my lord targeted the deceased.
All the reason why you should have been more careful.
And my lord, here in this case, out of 78 witnesses, till now, my lord, already 14 evidence of 14 witnesses already taken. My lord. And
At-
some of the witnesses are also protected witnesses because these are my lord ex-NDFB militants. So
How many? 78 witnesses.
78, my lord.
5 years.
Yes.
5 years.
5.
At least.
Are
Trial will take.
there the co-accused, some of the co-accused.
Even with day-to-day hearing, it will take 5 years. Otherwise, 10 years. It will pass others.
My lord, my objection regarding on the same line along with my lord regarding Darshan earlier regarding